Cockerill part heard in the matter of ADM International SARL and Grain House International S.A.
Yes, good morning.
May it please you, my lords. You may recall that in this matter I appear with my learned friend Mr. George Hilton for the appellants, and the respondents are represented by Mr. Lawrence Acker of King's Counsel, together with Mr. Patrick Dunn Walsh.
Yes.
The appeal stands adjourned from the 27th of June of this year. You will recall that the stage that we had reached was that I had completed my submissions, running in fact slightly over time.
Yes.
And Mr. Acker was underway with his address when the court adjourned in circumstances which you will recall.
Yes.
Lord, I'm pleased to say that Mr. Acker made a very swift recovery, and his indisposition turned out to be very temporary. My lords, we've been asked, because there's been a 6-month adjournment, to take half an hour each to recap on the arguments that we were making last time. And my lord, I propose to do that now, and I hope that I will finish that recap comfortably.
Yes.
Within the half hour that's been suggested.
Yes. We are very grateful to the parties for supplying us with volume 3 of the authorities bundle, and in particular the transcript of the hearing in June, which we have read, and that has helped us in reminding ourselves of what had been said at the earlier.
My lords, if I may say so, it's helped us too. And if there is a silver lining to the cloud of the necessary adjournment, it is that it's, in a curious way, the arguments tend to shake down over time, and the case, at least to me, appears perhaps a little simpler than it did first time round. I hope also to my lords.
Yes, very good.
So, by way of summary, you recall that there were 5 contempts found by Mrs. Justice Cockerill, the first 4 against the first appellants, the company, and the last, the 5th, against the director, Mr. Boutguery, for his part in all 4 of the contempts that were found against the company. The first 2 of the contempts were of a comparatively minor nature. They consisted of omissions from information that had to be given. Mrs. Justice Cockerill found that those contempts were technical, and she imposed no penalty in respect of them. We nevertheless argued that it wasn't simply a question of a technical contempt, but that there was no contempt at all in relation to those 2 matters. But at the outset of Mr. Acker's address, you indicated that you didn't want to hear, weren't going to call upon him on those matters, and of course we accept today that ship has sailed.
Yes.
But nevertheless, in our submission, and by way of recap, the technical nature of those first 2 contempts is in our submission relevant to a broader submission that we put right at the forefront of what we were saying last time, when we submitted that the evidence shows that Grain House International, the company, is a very substantial concern whose published accounts showed that it has assets, and has had for the last 4 years at least, assets of around about or above $250 million US dollars. And that the nature of those assets is set out in quite considerable detail in published accounts, which are, of course, have been, of course, available throughout to the claimants. And the
sorry to interrupt you. That was based on Mr. Boutguery's 6th affidavit, which I don't think you've sought to have admitted in evidence, have you?
Well, I think the position that I was putting last time was that at the sentencing hearing, the latest accounts were produced, and I was asking this court to infer that the earlier accounts were publicly available in Morocco and must have been consulted from year to year by the claimants. That's how I put it. But there is no actual evidence before the court that they've seen the accounts for the years leading up to the ones that were produced to the court at the sentencing hearing in January of this year.
I don't think we have any accounts, published or unpublished, do we? We've got the reference to to those in Miss Pritchard's first affidavit, yes, which you relied on.
Yes,
I think we're to December 2017. But otherwise, we don't have any accounts published or unpublished before the court.
We didn't put those accounts in the bundle.
Thank you.
The point I just wanted to make was that the GAFTA Award, which the disclosure orders and freezing orders were made in support of, was for just $4 million, which is obviously a comparatively trivial sum in relation to what would appear to be this company's asset base. And our submission last time was, which I just recap now, is that the respondents' problem has always been not that they had insufficient information about the extent and nature of the appellant's assets, but that all those assets were in Morocco, and that at least until very recently there have been problems about enforcement in Morocco because the Moroccan courts were not impressed with the circumstances in which the GAFTA Award had been obtained. And we were saying that, in fact, it's a reasonable inference that the claimants have been using these proceedings to exert pressure on the appellants, including by taking and asserting purely technical contempts and breaches which have no conceivable relationship with the practicalities of enforcing their award, which was, of course, the purpose of the disclosure order and the freezing order in the first place. And we say that although that consideration may be somewhat peripheral to the appeal against the convictions, it's certainly relevant to the matter of sentencing, which is before this court and which is a very important part of the appellant's case on this appeal. Turning to the two more substantial findings of contempt against the company and against Mr. Boutguery, they consisted, in contempt 3, of failing to disclose encumbrances of various properties owned by GHI, and in relation to contempt 4, continuing to trade in its assets while failing to maintain unencumbered assets worth at least $4 million, the amount of the GAFTA Award. Those two contempts, which the learned judge below found, were linked in that contempt 4 was predicated on the assumption that GSI's only assets were its properties, all of which were heavily encumbered, and that assumption, we say, ignored the reality of the situation, which was that this was a substantial company with, as I've said, very substantial assets. And I said last time, and I say again, I stress that there's no allegation here that in breach of the disclosure orders which were made by Mr. Justice Waxman did not include, and the contempt allegations following that did not include any allegation that the appellants had failed to identify what its assets in excess of $4 million were. To the contrary, the thrust of the allegation underlying contempt for was that the company had no such assets. So in relation to those contempts 3 and 4, we had, and I repeat, 3 essential submissions. The first was that on its proper construction, the order made by Mr. Justice Waxman ordering the company to disclose details of its assets exceeding US dollars 50,000 in value, whether in its own name or not, or whether solely or jointly owned, giving the value, location and details of each. That's Mr. Justice Waxman's order. The reference is Supplementary Bundle, tab 2, page 6. And that on its proper construction, that order was directed to the value of the assets and not to the value of the defendant's beneficial interest in any particular assets. The form of Mr. Justice Waxman's order was a standard one, and we say that that form of words relating to whether in its own name or not, or whether solely or jointly owned, etc., was developed in order to prevent defendants avoiding identifying assets in which they might have some beneficial interest, which would be of value to a claimant seeking to enforce an order. The whole point of an order in that form is to oblige the defendant to identify what assets he's got, which may be available in whole or in part to satisfy a judgment, and not to be able to avoid doing so or evade doing so on the grounds that somebody else has an interest in those assets. In other words, the obligation is on the defendant to say, here are my assets, this is what they're worth, it's up to you to decide what may be available when you examine the amount of equity which I own, to whether to enforce, and if so, how to do that. And we contrasted that form of words, and indeed the intention, we say, behind that formulation, with the orders made by Mr. Justice Ter and Mrs. Justice Mulder, the freezing injunctions which followed the disclosure order, which of course had a quite different function. The function of the freezing order was to ensure that the defendant didn't dissipate assets above a value of $4 million US dollars. And to that end, those orders made it quite clear that what the court was concerned with and what the obligation on the defendant was to tally up the unencumbered value, and those words were used in those orders. The reference for you, if you want it, is Supplementary Bundle tab 3 at pages 8 and 9. That's Mr. Justice Ter's order with that different form of words referring specifically to unencumbered value, and Mrs. Justice Mulder is at tab 4, pages 16 and 17. My Lords, so our first submission is that on its proper construction, there was no obligation on the company to do more than say, these are our assets, and this is the worth of those assets, and not this is the worth, and not to give details of the amount of the beneficial interest, which might have fluctuate from day to day. I think the evidence showed that at any rate, the majority of the charges on the defendants, the appellant's property, were there to provide security for fluctuating amounts of borrowing from banks. But the obligation was to say, to point the finger, these are the assets, this is where they are, and it's up to you to decide whether or not it's worth enforcing against them, trying to enforce against them, having regard to other parties' interests. But, my lords, our second submission is that if that's not right, at best, it must be said that Mr. Justice Waxman's order was ambiguous, because it could reasonably construed as either relating to the value of identified assets or to the value of the defendant's interest in those assets, and unspoken, but possible inference as to what the order really meant. And so we say it was ambiguous. We take support from that, from the case, the Court of Appeal case of Hadkinson, which is in your first authorities bundle under tab 3. And we say that that is Court of Appeal authority for the proposition that an unadorned reference to assets is inherently ambiguous. The court found in Hadkinson that assets didn't include assets which were in Mr. Hadkinson's name, but were beneficially owned by his wife. But they acknowledged that there was an alternative construction, that assets did include assets in which third parties had an interest, and that was a reasonable one. Hadkinson, if I didn't give you the reference, is in the first authorities bundle under tab 3, and the material part of that is at page 31 of the bundle, at letter G.
Thank you.
I also give you these references in support of ambiguity. First authorities bundle, tab 3, at page 34, letters B to C, and page 36, letters D to E. And our third submission is that if we are right, and you accept that that order is at best ambiguous, then a breach of it upon its proper construction is not a contempt of court, what we've called for shorthand the Redwing principle. My lords, our support for that is found again in the Hadkinson case, Court of Appeal Authority, particularly that passage from Lord Justice Mummery, citing with approval the judgment of Mr. Justice Ip in the Western Australian Bank case, which is now in your bundle, at Authorities Bundle 3. That's Authorities Bundle 3 at tab 2, that were saying, and Court of Appeal endorsing the principle, that where an order is capable, reasonably capable of two different constructions, it cannot found a contempt. My lord, since the last occasion, we have located, at the court's request, another case in which the so-called Redwing principle was considered by the Court of Appeal. That case is called Wilson and Wilson and Partners, LLP, against Emmett. And that's in the new authorities bundle, under tab 5. Lords, that was a case which had some parallels with with our case, it related to a freezing order which prevented Mr. Wilson from dissipating assets otherwise than in the ordinary course of business, familiar form of words. And the issue in the case was whether a particular disposition of assets which he had made was or was not in the ordinary course of business. At first instance, the court found that on its proper construction, the transactions that Mr. Wilson had been involved with did involve dispositions that were not in the ordinary course of business, and he was found in contempt of court. He personally was sent to prison, and the company was fined. But on appeal, it was found that on its proper construction, the order that was made had not been breached, and that the transaction in question was, in the Court of Appeal's view, within the ordinary course of a business, and the Redwing principle was cited. Of course, that was, as Mr. Acker has pointed and Mr. Dunwalter pointed out in new submissions for today, a finding obiter, because the court found that on its proper construction there had been no breach, and so the precise point which Redwing enunciates was not critical for their decision. They weren't saying we find no contempt because this order was ambiguous. Their finding was there was no contempt because on its proper construction, what you did was in the ordinary course of business. Can I just take, my lords, to the passage in Wilson where that's dealt with? It's at Authorities Bundle 3, tab 5, at page 106.
Thank you.
And it's paragraph 22 on page 106. And we can pick it up about a third of the way down. A second principle of relevance. Paragraph 22. A second principle of relevance is the approach to the interpretation of a freezing order. It's frequently been said that such an order must be strictly construed, and if there are two possible interpretations of it, a defendant who acts in accordance with one possible interpretation should not be held in contempt. And he cites Redwing and also Abliazov, but that is the Court of Appeal decision in Abliazov rather than the Supreme Court decision. He's referring to the judgment of Lord Justice Beatson in that case in the Court of Appeal. So while I acknowledge Mr. Acker's point that, strictly speaking, that is obiter, I do draw your attention to the ease with which Mr. Lord Justice Lewison was able to find, as it seemed a trite observation, a familiar observation, that the Redwing principle was correct, and so we rely on that.
Just picking up that passage, there are two separate points being made. One is strictly construed, and then the other is about contempt in the face of an ambiguous order.
Yes.
On strict construction, I understand the concept that if a statute or an order is aimed at preventing you from doing something, a strict construction would minimize the restriction on action. That's sort of I think that's the general concept of strict interpretation in this context. How do you apply it where, in essence, it's not a question of limiting something, it's just either A or B. Does the concept of strict construction have any application, and if so, what? Where in our current context, I mean, how should we apply the concept of strict construction, for example, to Mr. Justice Waxman's order, the relevant part of it?
Well, it could mean, in our submission, either the value of the property. If someone says, "What's your house worth?" you say 200,000. You don't say, "My equity in it is 200." The ordinary concept of value is, what is the asset worth? And then that's one construction. And the other construction, which is relied on by the respondents, is that it refers to the beneficial interest, because they say that's the point of making these disclosure orders, is to reveal where the money lies.
Because
that's the choice.
What Lord Justice Lewison goes on to say after the reference to JSB Bank is the words of the order must be given their ordinary meaning, but the purpose for which freezing orders are made will influence that meaning.
Well, those are undoubtedly words that the respondents rely on. They say the purpose of the order is to point to where the money is. There's no point, they say, in pointing to assets which have no value for the purposes of an enforcement. Our position is different. We say it's not the job of the defendant to work out whether or not the asset is something which may or may not satisfy a judgment. That's for the claimant. That's for the claimant to do. But what we have to do is to point to where the asset is and say now. And so, if you're looking for a purposeful construction, as opposed to the freezing order, which has a quite different purpose, different language, the purpose of this is to point the claimant in the direction of the asset and say that there it is. And it's up to you to work out what to do with it. My lords, those are the submissions I wanted to make about the Redwing principle and ambiguity. Lords, I'm going to ask learned friend Mr. Hilton to address you very briefly on the CPR point, and particularly as to whether you should give permission for us to develop a point here that was not argued before Mrs. Justice Cockerill. It seems to me that as it was Mr. Hilton who didn't take the point, it is appropriate for him now to persuade you that he should have a go now.
Yes.
And the Lord, have my eye on
I'm
the
not sure
clock.
that's quite the spirit of the new practice that's been dictated, but there we go.
Well, we had that in mind, my lord, the new direction.
Very good. And by my calculation, you have 5 minutes.
Thank you, Madam. Madam, we acknowledge the new point was not taken in the first instance, and we need your permission. The arguments we've set out in our skeleton argument in the core bundle, paragraphs 108 to 115, pages 41 to 42. Whilst in principle terms, the court should be cautious when exercising its discretion, which it has to admit this new point. It's clear from a reading of the authorities, in particular Singh and Das, and Notting Hill Finance and Shake, which this court will be very familiar with, that the court may give permission, and in doing so should exercise its discretion looking at all the relevant factors. And for that, I take into account in particular paragraph 26 of then Mr. Justice Snowden's judgment in Notting Hill Finance and Shake. All the relevant factors is referred to there. Those relevant factors will include those identified by Lord Justice Haddon Cave and Singh and Das at paragraph 17 and 18. The relevant factors we say in this case are fivefold. The first is that a new point that we're bringing requires no fresh evidence. It's a pure point of law. It goes to the court's jurisdiction and its validity doesn't depend on the resolution of factual issues. The second is that the respondent has had ample time to deal with the point, and in a related way, any detriment can be dealt with by way of a costs order. The third, we say that where, as is here the case, the liberty of the individual is at stake, the court should show a greater willingness to allow permission for the new point arising, and that's consistent with Mr. Justice Snowden's judgment in Notting Hill Finance, paragraph 26, where he identifies the nature of proceedings as being a specific factor to be taken into account. Fourthly, the nature of the new point is also a relevant factor that was identified by then Mr. Justice Snowden at paragraph 26 of Notting Hill. In that regard, clearly we have here a point of significant public interest. It's demonstrated by the fact that this was also a point that arose on the Novans Jets decision before Mr. Justice Foxton. And it's also very highly likely we would submit to arise again in the future, in the near future. And fifthly, this is a factor that's often discussed in the authorities, where live witness evidence was not, or was carried out at first instance, which was not the case here. There is plainly no reason here why that live witness evidence, which didn't happen, would be conducted any differently. And I suppose also it's fair to say that any evidence that was available at first instance would have been available for the respondents to rely on in the same way here before your lordships. So we say, taken collectively or individually, all of these factors militate in favour of the court exercising its discretion in allowing this new point, and also that would, for what it's worth, be in accordance with the interests of justice. My Lord Singh, I was proposing to briefly summarise the new point, and I can do so in 2 minutes.
Yes, please.
The new point is that old CPR 81.43, the power which contained the power of the court to commit directors for civil contempts, and when they weren't a party to orders, does not exist anymore. Our rationale is that whether intentional or inadvertent, the effect of the Civil Procedure Rule Committee's removal and revision of that provision in October 2020 was significant in that it removed the power that had existed in a continuous succession of statutory or delegated legislation that derived initially from Section 33 of the Common Law Act Procedure of 1860. There is no other common law basis for such a power, and we rely principally on the leading text for civil contempt proceedings, Arledge, paragraphs 12, 1 to 4, where it is said that, and that is in Authorities Bundle 3, tab 6, page 111 for the court's reference. But there it is said that were it not for the special provisions contained in the CPR, i.e. CPR 81.43, old CPR 81, there would be no common law basis for holding a director liable in contempt other than the general common law of criminal contempt, which applies equally to all third parties. We also rely on paragraph 12.132 of Arledge, which emphasises that point by saying that the power under CPR 81.4, old CPR 81.414, to commit directors seems surprising and apparently inconsistent with general principle. And separately, it also says that it represents a significant departure from the general approach. The general principle and the general approach are references, we say, to the general common law position. That paragraph in Arledge has been cited with approval of Lord Justice Beatson at paragraph 33 in Dar el Arkan Real Estate Developments, and that authority is a bundle in the first bundle at tab 9, page 225, paragraph 33, for the court's reference. The general common law principle or position includes the principle in Solomon and Solomon, which came into effect in 1897, meaning that directors of companies are not ordinarily liable for the company's breaches of orders without more. We also, that is the positive element of our position for saying that there is no common law basis.
Solomon and Solomon, wait a minute, Solomon and Solomon wasn't to do with breaches of court orders?
No, it wasn't. My lord, we say
a separate corporate personality.
It established that there was a separate corporate personality, and the corollary of that, we say, is that this separate personality that was party to an order would not. It means that they face the consequence of breaching in the order. The company does, and not other legal personalities. But we also, I think, we do rely on the fact that there is no common law case origin that has been identified either by Mr. Justice Foxton in the Novens Jets case, or we say by the respondents. What Mr. Justice Foxton did in Novens was determine the point on the basis that CPR 8143 was effectively resurrected by reference to the general scope provisions under the new CPR 81.1 subsection 2 and 3, and the definition of penal notice under the new CPR 81.2. That, however, presupposed that the old 8143 rule continued in existence, and neither, which obviously it didn't, and we say that neither of those new CPR provisions positively empower the court in the same way that old CPR 81.43 did.
Can I raise two matters? First, Singh and Das. I wonder, and this is a point potentially in your favour, but you may tell me I'm wrong about it. I'm wondering whether those principles apply at all to a case in which one's dealing with committal proceedings where they are criminal in nature and there are penal consequences. And it might be said that the analogy ought to be that which arises where there's an appeal against conviction in a criminal case and a new point is sought to be taken on appeal. And in that context, it depends what the point is, but it's well established that if the indictment charges an offence which is not known to the law, then the conviction ought to be quashed. And that's whether the point was taken below, and indeed if there was a guilty plea. And your case, if you be right on this point, is that the contempt number 5 with which Mr. Boutguery was charged was interpreted as involving a civil contempt, and that is not a contempt known to the law, and that applying those principles for that reason, the point of law ought to be allowed to be raised, because any finding of contempt ought to be quashed in the same way as a criminal conviction. Now, you may tell me I'm wrong, or you may say you'd like to adopt that.
My lord, we would naturally like to adopt that point. I mean,
Yes.
I think it's fair to say that there is no decision that we have found that's directly on point. So that analogy is a fair one, we would suggest. It struck me, as I said, that the considering all the factors, including the specific reference by the then Mr. Justice Snowden to the nature of the proceeding, would be where that point comes across in my submissions. But however your lordship would like to phrase it, we would like to adopt that point.
Thank you. And then the second point I just wanted to raise with you is this. You say no common law case identified either in Novans or by the claimants where the civil contempt principle has been applied to directors. But I've been delving a little bit into the history of the position prior to 1860 and what was meant by writs of attachment and mandamus as it existed at the time of the 1860 Act. Mm. And what that appears to show is that the writ of attachment was originally a form of process for bringing a defendant before the court generally. but it came to be used as a form of arrest in support of contempt proceedings. And an order made against an individual could be enforced by contempt proceedings by a writ of attachment to bring him before the court to answer for it. And then there were remedies of committal or imposition of fines. There was also, referred to in the 1860 Act, the writ of mandamus, which had also been used prior to 1860 as a means of enforcing orders and in support of contempt. And it was recognised that you couldn't attach a corporation because it had legal personality and attachment involved physical arrest. But what you could do, and what the cases suggested you could do, was that once you had an order against a corporation, you could get a writ of mandamus addressed to officers of the corporation, essentially to see to it that the corporation performed the obligation by way of court order. And there are a number of cases. Glyn and Cope is one, Men of Guildford may be another. There's Inri Bamborough is another, in which mandamus would issue against the individual directors, essentially, to see to it that the corporation performed its obligation. And that then seems to have been conflated. It involved a rather cumbersome procedure because you had to get the order from the court itself, which might be a money order but might be a mandamus. That was addressed to the corporation. Then if the corporation didn't apply, you had to get a separate writ of mandamus against the individuals, and then you had to enforce that by your writ of attachment against the individuals. But it looks from the writings as though that was then conflated into a general understanding that the rule was, or the principle was, that if you got an order against a corporation which it failed to comply with, you could attach the directors and officers. And that's essentially what the 1860 Act said you could do without going through the separate stages of getting a separate writ of mandamus against the individual directors and officers. Now, I raise all that because that's what I've seemed to have found in the researches, but that all does suggest that there was a principle. I would probably call it substantive, but it may not matter. There was a principle which existed before the 1860 Act, which enabled, through these procedural mechanisms, directors and officers to be made answerable to see to it, if they were responsible, for the performance of the obligations of a corporation under a court order. And that would suggest that it was a principle which wasn't created by the 1860 Act. It existed quite independently of it. Now, maybe you're not really in a position to say very much about that, but I thought I should raise it because that is what it seems to me the law shows.
Well, I'm grateful. You're right, I'm not in a position to deal with that fully. However, it sounded like it was perhaps a slightly different procedure than was anticipated. It also, at a time that predated the Solomon decision, my learned leader may have something further to say when he responds, as I think his intention is after Mr. Acker has spoken.
Yes, well, you're certainly entitled to ask him to deal with it.
But I fear on the spot I'm unable to say.
Yes.
Yeah.
Reply, just...
Yeah, so what I would say is that in relation to the two authorities, I'm not sure these were the authorities that your lordship mentioned. But Guildford, I think, Lena has said was.
Yes.
That was referring to members, and members has always, as I understand it, having considered the point in Stroud and Jowett, had a meaning that related to shareholders, not directors and officers.
Well, that report is a bit exiguous, and it may therefore not be possible to be sure that that is an example of the principle that I've been describing, although it was treated as such by Stephen in his work on the 1860 Act. But Cope and Glynn, for example, was a case of a dock company whose constitution provided that it could sue or be sued through the treasurer, and it incurred a commercial debt. There was an arbitration award, and the award was made a rule of court. I think it was for £2,500. So there was a money order of the court for £2,500, and the claimant sought to simply attach the treasurer on the basis that the Constitution said the treasurer can bring and defend proceedings. And the court said no, that wasn't what the Constitution meant. His assets, the Constitution didn't make his assets immediately available, but what could be done, and was done in that case, was that an order of mandamus could be directed to him and the other directors of the company, and that if they then failed to comply with it, i.e. to see that the dock company fulfilled the award, they would be personally liable to attachment. So that does seem to me an example of the principle that I was expounding.
Your Lord, again, I would need to read the case, but I mean, what I think is stark and apparent is Your Lordship has delved into a very ancient authority by modern standards, and there is no reference to that common law power in any of the other authorities that have existed since then, which seems slightly surprising, and without considering the text itself, if it is anything like the reports of Guildford and Mills and London and Lynn, we would say that the court should treat it with some suspicion as to the accuracy and the meaning of what it says. But I'm making very general submissions without having considered the material.
And then there's one other point I perhaps ought to raise because it's in my mind so everybody knows, which is that consistently with that, when we get to Tuvalu, which is really the leading authority on defining what's meant by responsible for bringing directors and officers within the scope of the civil contempt in this context. Although at that stage there was the equivalent of what was subsequently 81.4 in Order 45 of the Rules of the Supreme Court, Lord Justice Wolfe didn't treat it as an exercise of construction of that rule in deciding when directors and officers should be responsible. Essentially, he laid down what the law was or ought to be as a matter of general principles. There's nothing in the wording of that order which led to the conclusion. He didn't purport to be construing the order or construing any wording in the order in order to set out the principles that were there described.
Sorry, Your Lord.
So the point I'm making is Tuvalu is consistent with the idea that this is a principle of law which is not to be found in the rules of court, but in the inherent jurisdiction of the court to punish for contempt.
Well, Your Lord, my Lord, I think given the existence of the statutory basis for that principle, we I think would say that those comments are commentary as to how the statutory order ought to be applied, and aren't themselves seeking to set out a general common law principle. Again, my learned leader may have more to say on that subject.
Yes.
As I understand it, is this right? You say, well, even if the common law provided prior to 1860 a rule of law that allowed for directors to be, or those involved in running a corporation to be proceeded against for contempt if the corporation didn't do what it was supposed to do. That, as I understand it, you say that once that became embodied in the statute or rules of court, and then not continued after the recent changes to the CPR, we've deliberately or otherwise done away with the common law.
Yes.
Is that? I mean, in other words, the common law doesn't survive being incorporated into statute and rule, and then the rule being, it doesn't revive, as it were, on the statute or rule being displaced. Have I misunderstood? I mean,
Well, my lord was saying that we originally submitted that there was no common law basis, but I think it follows that if my lord Popplewell is right, then we would accept that analysis. So such common law basis that did exist, once codified in the statute, ceased to exist other than in the statute. And once the statute was repealed and replaced in October 2020, inadvertently or otherwise, meant that there was no longer power for the court to commit direct or civil contempt.
Yes, I understood from paragraph 13 of your supplementary submissions that you were submitting essentially that the true issue and the only material issue is whether the court's jurisdiction to make orders for committal in respect of breach of court orders by companies against companies' directors is inherent and or is based on pre-existing statutory or common law, i.e. pre-existing the 1860 Act, independently of the former CPI 81.4, in which case the purpose of CPI 81.4 was merely to serve as a reminder of existing law. If so, the repeal of 81.4 would leave that jurisdiction unaffected. If not, repeal of 81.4 remove the sole basis for the jurisdiction. So, as I've understood your case, if it's inherent jurisdiction or based on law which existed prior to 1860, then the abolition of 81.4 doesn't affect the position. If it's contained in the statute and then the procedural rules and ultimately 81.4, then doing away with it does away with the principle.
Yes, that is what our supplementary submission state.
Thank you.
Thank you. Well, that's been helpful. What I suggest we do now is hear from the respondent, which deals with this in its supplementary submissions, which we've had in the last week or so. And then, of course, Mr. Moxon Brown can reply on these points as well. Thank you both very much. Yes, Mr. Ack.
Good morning. Can I begin, if I may, as invited, with a brief recap of the ground we'd covered last time?
Yes.
Hopefully without the loud thud at the end.
Yes, and can I remind you, Mr. Acker, that we don't need to call on you in relation to contempts 1 and 2.
Yes, I wasn't going to deal with those, but good. I started with some points of general application to do with the advancement of new points and new evidence. We've heard a little bit about that this morning. Clearly there are new points being run here, notably the Part 81 point, possibly also some other points. It's a little unclear to what extent they're being pressed. To some extent, I think, again, having heard him this morning, the learned friend relies on the new evidence, though precisely to what extent is not entirely clear to me. As to the admission of new evidence, of course, that is governed by CPR 52.21(2), which gives the court a general discretion. It's governed, if I can use that word in inverted commas, also by the Ladd-Marshall factors, but those are said to be factors relevant to the exercise of discretion nowadays. Subject to this one point concerning loss of liberty, which I'll come back onto in a moment. As your Lordships pointed out, there's been no application to admit new evidence. It was not obviously made available to the judge on or for the purposes of determination of the contempts. It may have been available for the purpose of determining sentence. It quite clearly could have been produced at an earlier stage if the appellants had wanted to produce it. Indeed, they positively chose deliberately not to do so, and so it's not in the interest of justice to admit it now, at least for any purpose other than sentence, where I will suggest it makes no difference. As to the quality of the evidence, I said last time, Mrs. Justice Cockerill described it as an unfocused mass, which it is, mostly in French and Arabic. It was entirely unheralded. That has not improved since. Even Mr. Moxon-Brown said before Mrs. Justice Cockerill that further work was needed to analyse that evidence because there was not sufficient detail. He suggested an accountant would have to look at it. None of that has been done. And it needed to be reconciled, he said, with other material. He said, in fact, it was not fair to require us to deal with it at the time it was produced. So I invite the Lordships to disregard any points insofar as they are based on the new evidence. As for new points, rather than new evidence, we looked at Singh and Das and the Notting Hill case, and the principles have been rightly stated as being your Lordship should exercise caution, shouldn't generally allow new points if they would require new evidence or would have resulted in the trial being conducted differently, or if we're not adequately protected in costs. We do say, and will say, and I'll come back onto this when we look at Part 81, that either the new points would have necessitated different evidence or would have resulted in the case being run differently by us. For sure, there is no adequate protection for us in costs.
So can you just explain that to me?
I'm sorry, my Lord.
The first of those points. You'd drafted your contempt application,
Yes.
and you'd put forward the evidence that you sought to rely upon,
Yes.
and you'd had in response the evidence in response.
Yes, well,
if at the hearing, it wouldn't have been too late to take this as a point of law at the hearing.
no, I think that is probably right, my Lord.
So how would that have
yes,
affected
I shouldn't have
the
said.
evidence?
I shouldn't have said evidence, and we would certainly have invited her ladyship to conclude, based on the evidence that she had, that there was sufficient material there to convict Mr. Boutguery on to the criminal standard, if necessary.
Sorry, you mean for criminal contempt?
For criminal,
as opposed
sorry,
to
for criminal
civil contempt?
Yes.
But that wasn't what he was charged with.
Well, my Lord, it may be that that's open to us on the wording of the particulars of contempt. Your Lordship may remember there was a discussion.
I mean, I am aware that the wording is not perhaps wholly felicitous,
Yes.
but the basis on which it was put to Mrs. Justice Cockerill, as I understand it,
Yes.
was this is a civil contempt.
Yes, because
And that's what this means.
yes. Well, my Lord.
It can't mean both.
Well, my Lord, the words concerning that it is debatable, my Lord, certainly that I say that I was going to say indictment, but the particulars of contempt were wide enough to encompass criminal contempt as well. Indeed, my learned friend has made points at that. He said we were suggesting that there was a criminal contempt there, and that was wrong.
So when you, just so I've got your submission, when you say we would have run the case differently, you would have
What I mean is
contended that the
we were entitled to
contempt
do it.
charged criminal contempt, and secondly contended that the evidence established criminal
That
contempt.
it was open to us to charge criminal contempt on the wording of the particulars of contempt as well as civil contempt.
I'm trying to switch on from the discussion we may have had on previous occasions, so give me a moment and let me catch up. But do you not have to get permission to bring criminal contempt proceedings on the court?
The honest answer is I don't recall, my Lord. That may be right, and that may be a stumbling block.
I thought the difference between a civil contempt and a criminal contempt was that criminal contempts require permission to be brought.
Certainly I'm aware some do. Some require permission from, I think, the Attorney General. Some may require permission from the judge. Can we check that? And
Yeah, I may be
come back.
wrong. Who knows?
I feel your logic may be perfectly right, and we'll address that.
Certainly, the Attorney General sometimes
Yes.
brings contempt proceedings,
Yes,
usually heard in the divisional court, and certainly I've presided in hearings of that sort.
yes.
What I'm not at the moment sure of is whether there are other circumstances in which a criminal application can be brought to the attention of the court without somebody's permission.
I also am not sure, but we have a white book, and Mr.
All
George
right.
can have a look at that. And can I come back to that, if I may, when we deal with Part 81?
Yes.
But the short answer, well, an answer to Lord Justice Popplewell's question as to what we would have done. If we needed permission, we would have asked for it. We may not have got it.
Yes.
If it had been said at the hearing itself, well, the point we want to take is that Part 81 is no longer available, or committal of a director is no longer available under Part 81. We would have asked for the necessary permission, and we would have invited the judge to conclude on the basis of the evidence that Mr. Boutguery was sufficiently personally involved in all the matters, that the necessary mens rea is proved and the necessary ingredients of criminal contempt are proved.
Right.
Thank you.
And of course, we may not have been successful on that, but that's
Yes.
that's a different matter. I obviously can't take it any further than that because it's a hypothetical. For sure, also, we say there's no adequate protection for us in costs because no costs orders have been paid to date, even though those cost orders are not the subject of this appeal. This is by GHI. Similarly, the award has not been paid, notwithstanding assertions which we say are hollow, that the respondents, the defendants intend no disrespect to the English court in any way. They haven't paid the award.
Again, that's all right. I just made my fault. Can I just spell out, or ask you to spell out what order for costs potentially we're talking about?
Yes,
the hypothesis is that the point succeeds in this court.
Yes.
In which case, so far as the costs of the appeal are concerned,
Yes.
if it were the only point,
The appeal would have been
then-
unnecessary.
then we're not talking about a cost order in your favour.
No.
And so far as the costs below are concerned, if it be the case that because the point is right in this court, the contempt could not have succeeded below,
Yes.
you may be able to say you shouldn't have to pay all the costs because the point wasn't taken below. There's difficulty in seeing how you would be likely to get an order for the costs below to be in your favour.
Yes. Well, the appeal would have been unnecessary because if the point had been taken below and had been successful below, we wouldn't be here appealing about it.
I thought you said the point was wrong.
Oh, well, yes, no,
You contend the point's wrong, but you wouldn't have appealed it.
Lord, I mean, maybe the better way to put it, in fact, that was a terrible way to put it. The better way to put it would be to say that there will inevitably have been some costs caused by the point not having been taken and having been dealt with by the judge at first instance.
Sounds to me as if this is classically a case where you could be adequately protected in costs. I think you're making a different point, which is that they don't pay costs.
Yes.
That's a different point.
Well,
You may have to take action to enforce costs orders, but
yes.
But
I
it
mean,
does
that is the point.
seem to me, at the moment at least, that you can be protected in costs if we allow the new point to be taken. One outcome would be, and I don't prejudge this at all because we haven't reached that stage,
Yes.
and we haven't heard any arguments about it. But one outcome would be that we allow the appeal on that ground if it has merit, otherwise, but we don't give them their costs. So that protects you in costs.
My lord, I see that.
That's one outcome. That's, but I have to say, I have no preconception about any of this.
Yes. My lord, it is, well, it was intended to be a short point that
Yes.
they haven't paid costs orders
Yes.
to date. Therefore, there is a risk, we say, that they
Yes.
won't pay any relevant
Yes,
costs
well, we
orders.
understand that submission.
And perhaps I hadn't bottomed it out as much as I thought, as much as I should have done. But but that was the point we were making.
Yes.
And of course, to some extent, that applies in relation to GHI, and not in relation to Mr. Boutguery, because he hasn't failed to pay costs orders to date, apart from those which are under appeal. But we make the same point in respect of him because he was in charge of GHI at the time. My Lord, there was some discussion last time about the applicability of the authorities on new evidence and new points where the liberty of the subject is at stake.
Yes.
So for Mr. Boutguery's appeals in particular, not necessarily for GHI, we like my learned friends, found nothing dealing specifically with new points. I did say I think I had in mind there might be an authority dealing with ladder marshal, which unhelpfully I recall might begin with an I. I was in fact right about that. The case I was thinking of was Italian Squattriti, which we referred to in our supplementary skeleton at the end. I won't say anything about that because it's ultimately a matter of discretion. I think your lordships accept that. It was in 1993, it's a pre-CPR case. That says essentially that where one is in danger of losing liberty, the court will apply by analogy Section 23 of the Criminal Appeal Act 1968, which says that evidence can be admitted essentially where justice so requires. I think the wording is where it's necessary or expedient in the interests of justice.
Yes.
For completeness, my lord, that case has itself been doubted on other points because it says things slightly odd to modernise things about the mens rea in relation to contempt. And there are at least a couple of judgments which I've referred to in the skeleton which don't cite it, but nevertheless appear to apply the ladder marshal guidelines to their full extent, even though they're cases where the liberty of the subject is at stake. My lord, we do say clearly that even if one is minded to apply the more generous, if I can put it that way, criminal test either to evidence or to new points, Mr. Boutguery's appeals still fail. Moving on then, if I may, to contempt 3.
Do you want to say anything more about the point I raised with Mr. Hilton?
My lord, I understand that. It's difficult for me to say anything about it. Ultimately, as I said earlier, it's the admission of new points is a question of discretion. The point you put to Mr. Hilton as to whether or not there is some, if I put it this way, principle of justice, which says if the charged offence isn't in fact an offence, then it should be set aside essentially as of right. My lord, I have to say I can see that, but all I can say is what we're dealing here with is a civil contempt, albeit one which is quasi-criminal in nature, and it doesn't necessarily follow that the same principles should apply. I anticipate, of course, that your lordships will want to go and deal with Part 81 anyway, and we will come on to deal with that. So skipping over contempts 1 and 2, contempt 3, the failure to disclose encumbrances. The history of this, of course, is that the order required the defendants to state all assets in Morocco greater than $75,000 in value, giving their value, location and details. Originally, what happened is that, well, nothing happened for 2 years. After 2 years, we got some vague location and description information. It was only in Mr. Boutguery's second affidavit, which I think was 21st of April 2021, that we got some more details, in particular the gross value of the properties. No detail as to the extent of GHI's ownership interest in those properties. They did at least say that some charges or mortgages existed, and for a couple of properties, I think they actually said there were none. So a positive statement that there were none in relation to at least a couple. In fact, of course, the list was grossly inadequate. There were some 19 encumbrances that had not been disclosed in the list of encumbrances, including for at least one of those properties where they'd said there were none, there were in fact some encumbrances. A significant point is that nowhere in the six affidavits, I think, and one witness statement, nowhere in that evidence in total did they say that they believed they did not have to disclose encumbrances. What Mr. Boutguery did say, however, is that they didn't comply at all with the asset disclosure order for such a long time because they thought they didn't have to. And various excuses were given, such as we didn't know it applied in Morocco and we didn't think it was fair and all the rest of it, all of which has been dealt with elsewhere. And in his sixth affidavit, at paragraph 14, he says that they only thought they had to disclose encumbrances after the freezing order was issued. So that was why we got some encumbrances listed earlier.
So that's in his sixth affidavit?
Yes, it's...
Is that in evidence?
Yes, it's in the supplementary bundle tab 19, page 153.
Right, thank you.
And it's paragraph 14, where he says, with regard to the value of the property declared, we made an error of interpretation and judgment that was in no way intentional. We were under the impression that we were only supposed to declare the encumbrances that entered into the register after the WFO was issued. So he had to explain why he'd listed some, or why Mr. Umari on his behalf had listed some encumbrances, but not others. And as I say, various excuses were put forward, which were dealt with by the judge. This was the main excuse put forward, not that we didn't think we had to disclose any at all. So as I say, the judge made short work of that. She held that there was no basis for that interpretation on the wording of the order. The order didn't say anything about you only have to disclose encumbrances after the date of the freezing. And she said she was sure on the evidence that GHI knew of all the encumbrances, even though they'd claimed not to be, but chose not to disclose them. And that's paragraph 77 of the judgment. She didn't accept their protestations of not really understanding. She said that they had English legal advice available to them and that they either chose not to take it or they ignored it. And indeed, there were a significant number of inconsistencies in what they'd said in the documents. So their evidence was positively disbelieved on this point. I suggest, therefore, and suggested last time, this is not a case where there was any genuine relevant misunderstanding about the scope of the order as to encumbrances. There do arise then two questions, of course. The first, which has been described as going to the meaning of value, though in fact, as I said last time, technically it's both value and details which matter. And the second is Learned Trend's proposition that if an order is ambiguous, then whatever it means and however the defendant understands it, there can be no contempt. If I can just then recap what I said about those in turn. As to the meaning of value, obviously we say the judge was right to conclude that the meaning is in fact obvious. This is not a case where there is any ambiguity or any doubt about the proper interpretation of the order in the context in which it was made. And for that purpose, we respectfully adopt the reasoning of the learned judge, paragraph 74 and following.
So you say what the order should be read so as to the numerical values are the net values, net of encumbrances, and
interest in the, yes, that's what matters.
So net of encumbrances.
Yes.
And that's, are we going to go to the order to have a look at that? Or can we?
We can do.
Are you planning to do that?
I was just going to recap essentially what I said last time and the points that your lordships put to me about the wording of the order last time.
Okay, you recap, and if your recap doesn't cover the point, then I'll pick you up. Yes.
So I say this is not a case of ambiguity at all. It is obvious, and the judge found it was obvious, and she said it clearly means the unencumbered value because one looks at the wording of the order in the context in which it is made, And the reason for an order such as this being made is to disclose to us what value is available to us for execution purposes in order to satisfy the judgment, the arbitration award in this case. And the judge said, and we say, that there would be no point in that context for us to know the locations of, and these brackets are hers, brackets worthless assets with a brackets meaningless value of $4 million. And she thought there was no scope for dispute that the order had not been complied with on that basis.
That assumes that the encumbrances are something which remain fixed for all time. If you have a very valuable property over which there's a floating charge to secure debts, which at the time of the affidavit of assets means that there's almost no equity.
Yes.
But once the debt has been paid off, it will be very valuable. And it's certainly something you'd want to know, isn't it, for the purposes of seeking to enforce the award.
Well, the difficulty, if I can put it that way, with that analysis with respect, is that there are always things we would want to know. I mean, ideally, we would get an order that they disclose to us the gross value of all their assets, tell us which assets are encumbered, tell us to what extent they're encumbered as at the date of the affidavit, and keep us updated on a daily basis going forwards. But no commercial court judge is going to give us an order in those terms, even though we are a judgment creditor, and the benefit of the doubt, if one could put it that way, is in our favour, because the policy of the law is to enforce, assist people seeking to enforce judgments. And that is the basis of the jurisdiction for disclosure orders in the first place, particularly post-judgment disclosure orders. So I do say one needs to be a little careful about thinking, well, there are other things Mr. Acker's clients might have wanted to know. Of course, that's the case. But what we wanted the judgment for, and the reason we asked for it, is so that we can, if I put it colloquially, get a quick win, find out what large assets there are, not the small ones. We don't want the piles of paper clips and staplers. We want assets which are worth over a particular value, which is set as a matter of judgment, which on the face of it are available to be enforced against easily. So we don't want to know, here is a property worth 100,000, but it has 100,000 mortgage on it, because in practice, I mean, yes, we would like to know that, but in practice, one has to balance the interests of the applicant with the interests of the respondent. And what we're really looking for is cargoes afloat, or we're looking for an unencumbered land somewhere which we can seek to enforce against. That will help us target our efforts. Of course, at a later stage, because we will be, if that enforcement is not successful, we will be pursuing the defendant through appropriate court measures in local jurisdictions and wherever, and we will find out about these assets in due course.
Can we just test that and pick up my Lord's question to you by reference to the terms of the order itself?
Yes.
I mean, I've got it at page, it's Mr. Justice Waxman's order, so page 6.
Yes. Supplementary bundle.
The 22nd of March 1929. So, before we go to B and C, can we just look at A, please?
Yes.
Now, A specifically talks about wanting to have disclosure of bank accounts with a balance exceeding $50,000 US dollars.
Yes.
So just pausing there. First of all, there's no reference at all in relation to that to disclose. Cheers. Just hope this hearing isn't jinxed.
It wasn't me, Lord.
Right, I'll just have to query.
Yes, it doesn't talk about it.
Right,
Encumbered
so
or unencumbered value.
now, picking up my Lord's question, my Lord's point, most corporate bank accounts, certainly in this country, are covered by charges of some sort, usually a floating charge in favour of the bank to secure the lending. So, on the face of it, that 1A just looks at the gross amount. It doesn't ask you to form any assessment as to the equity which, as my lord points out, would be extremely difficult in relation to pretty much every bank account in this country owned by a company, because it would be covered by a floating charge which would vary from time to time. Now, why should anybody looking at that think that what you were asking for, or what they were required to do, is to value the net equity in the bank account, when on its face it talks about the balance, which is the which is the gross amount of a bank account?
Well, I think I have to accept that's right. It's a point Lord Justice Popplewell put to me last time.
Right.
A, of course, doesn't refer to the value. It refers to the balance, and there may be reasons why a bank account is treated differently because it's in possession of a third party.
Well, but if A is clear that it doesn't require disclosure of the unencumbered value, but it just requires disclosure of the gross, the balance, can we then move on to B and C?
Yes.
B just says all other assets located outside Morocco. Whose assets? Where in B and C does it actually identify whose assets are actually that you're actually interested in?
Yes, well, I suppose it doesn't express them all, but it does by necessary implication.
Where do you get that implication from?
From the purpose of the...
Well, don't you just get it from A? In the say where A says all of the defendants' bank accounts, and then if you're saying B and C by inference is limited to the defendants' assets,
Yes.
if you're referring back to A, that would, it says all other assets, namely other than we've just mentioned in A,
Yes.
owned by the defendant.
Yes.
You're going back by reference then to something which doesn't require you to disclose encumbrances and which requires the gross. So why do you say no, B and C are different from A?
Because they talk about the value of the property. Or put it another way, they don't talk about the balance. I can see that the balance has a particular meaning.
Well, it's other, yeah. I mean, B and C most definitely. Do you accept they ask you to inferentially refer back to A? Certainly,
of course, Lord, yes, and they're they're in the next paragraph anyway. So yes.
But you say it's to be read differently from A. A doesn't require you to deal with questions of encumbrances or indeed to give any details of any encumbrance over the bank account. But B and C are different in character. I mean that's as I see it, the point put against you, and I'm just going to wrestle with my chair for a moment.
Yes.
If that's all right.
Yes.
Can I take the opportunity to ask you something else about how this works? How do you say this works if you've got a single debt which gives rise to a charge on a number of different properties? You've got 5 properties, they're all worth $100,000, and they're all charged to the bank to secure a debt of $50,000. Do you have to disclose any of them? Or are they all below the level?
So that it is
They're all encumbered to the
impossible
extent
to
of
say.
50,000. They have a gross value of 100,000. On your interpretation of the order, do they fall to be disclosed?
I can see difficulties there. Is your lordship suggesting that it is effectively impossible to say whether what the extent of the defendant's interest in each of those properties is?
No, what I'm looking at is whether your interpretation gives you what you would want to know. Because if, as might appear to be the case, that in relation to each property, the beneficial interest is only 50,000,
If that's the
then
case,
there's no obligation to identify any of them.
yes.
And yet, there is $450,000 worth of unencumbered assets spread across the 5 of them, which you'd absolutely want to know about.
Well, that is, if I may say, an inevitable consequence of there being a financial limit in the order. One might say, if there's an order that says you must disclose assets over $75,000, and there are lots of assets, whether charged or not, which are worth $70,000 each, does the defendant have to disclose them? And the answer is no.
But it's not the consequence of Mr. Moxon Brown's interpretation, because under his interpretation, you don't get details of the encumbrances, but you do at least get disclosure of the gross value of all the assets for you to be able to investigate the position.
Yes, but one wouldn't.
You don't know about them at all.
Yes, I mean, but the same would apply if, forgetting any encumbrances for the moment, supposing nothing is charged, there are a number of properties worth $70,000 unencumbered. That none of them is disclosed to us on anybody's interpretation. Your Lordship could say to me, well, wouldn't you want to know about those? The answer is yes, I would love to know about those, but that's not what the order entitles us to. And that's why I say it's an inevitable consequence of there being a financial cut-off. There are always going to be edge cases and hard cases which take the value, whatever the value means, to just below the financial cut-off, and there will be no disclosure in those cases.
But again, picking up my Lord's point, if you have 5 assets, each of which has a gross unencumbered value of, say, 100,000,
yes,
but they are each the subject of a fixed and floating charge, or let's just say they're each subject of a charge to secure indebtedness, which is 100,000. Now, the creditor, the bank, let's say, has a choice.
yes,
He can enforce that security over any of those assets at his choosing.
yes,
So you might say that actually in relation to each of them, given that they're all potentially subject to enforcement by the bank,
a single charge.
that in fact there is no equity in any of them.
Yes,
Now, that's not what you want. You want to know each of the 5,
Yes.
because if the charge is enforced over one, the other 4 are released, and there's all the equity. But how do you work your, without being specific in the order? How is it supposed to work for a defendant in these circumstances?
Well, in those circumstances, if the position is that it is not possible to say in relation to any one property whether it is in fact worth more than 75,000, because it might be the subject of that charge.
Well, it is the subject of a
It is the
charge,
subject of a charge.
which secures a debt of 100,000
Yes.
on that question.
There will ultimately be an answer to the question of what is the value of the defendant's interest in that property. It may be that the defendant has to disclose that he has five properties, each of which is worth 100,000, but between them are subject to a charge which might reduce their value below that. But it comes back to this point, my Lord, that your Lordships could put to me various circumstances in which there would be substantial assets which we might want to enforce against, and say to me, wouldn't you want to know about those? And the answer will always be, yes, in an ideal world, I would want to know where all the assets are so that I can choose which one's best to enforce against. But that's not the purpose of the order. The purpose of the order is not to tell me every asset, it's to tell me every asset worth more than a particular amount, to strike a balance between the defendant needing to disclose, as I say, all the paper clips, and producing for us an asset which we can easily enforce against.
Can I raise another
Yes.
question? In an ideal world, you would want details of both gross and net.
Yes.
This order doesn't mean that. Neither of you contend that it means that. We've got to construe it as meaning one or the other. But one knows that for the purposes both of freezing assets with a view to enforcement and enforcement itself, it is very often the case that recalcitrant debtors, which is how I'm sure you would describe these appellants, will say things about beneficial ownership,
Yes.
about assets, which don't bear examination.
Yes.
It's not my house, it's my wife's house.
Yes.
And if you're writing your order, you never find out
Yes.
about the house at all,
Yes.
which is quite a large hole, isn't it, in what you would want to know. You would much rather that he simply said, here is a house worth 5 million in my sole name.
Yes.
And then when you want to enforce against it, and he says, it's my wife's, you can investigate that and say, no, it isn't, and enforce, then find yourself in the position in which he simply doesn't disclose it, because he claims that it's in his wife's name, but he won't have to say that in an affidavit.
Yes.
He'll simply not disclose it.
Yes, and there is certainly a degree of self-policing involved. I think we would say two things. One is that if they are going to lie about sham trusts, or however one wants to put it, or lie about beneficial ownership, then they're going to lie about it anyway, so the order won't necessarily help us in our enforcement, subject to us finding out about it and then committal proceedings. And the second is that point, of course, has been dealt with in the context of freezing orders by the Solodchenko case, which is the great Ablyazov saga. And there is optional wording for the standard commercial court freezing order, which talks about, I think, whether the respondent is interested in them legally, beneficially, or otherwise. And it's said in Solodchenko that that's there to cover the sham trust point, but it's not a permanent part of the order, because it may or may not be appropriate in any given case. In this case, certainly we had no suggestion available to us that there was any issue of that kind which would require to be dealt with in the order. If we had wind of, or earlier disclosure suggested that there was some sort of, we don't have this asset because it's not actually ours, it's our parent company's, or it's held on trust, or something of that sort, then we might have sought further orders. But again, in a sense, that's saying, what if there had been a different order? Wouldn't have that been better for you? And the answer may be yes.
As I say, ideally, you'd want to know both. But that isn't this order, and we've got to decide when we're looking at what better fulfills the purpose, which is the context in which we're looking at it.
Yes.
Does gross better fulfil the purpose than net? As I see it, that's part of the exercise we must be engaged in.
Yes, because one is construing it against the background, and I've said to your lordships what the lady judge thought the relevant background was and what the consequences of that were, and we adopt what she says. It's also the position in the context of freezing orders, of course, in Aspinall and Lim, which is the case that was cited below, which we've looked at. That cites G, who has the same view in relation to the disclosure order in a freezing order, and indeed the view of Miss Joanna Smith, as she then was in another case, where they all held that value must mean realisable value, as I say, in the context of the disclosure provisions in a freezing order. But I say the context here is no different in substance. The context is no different, and clearly the surrounding words are different, but we are still seeking information for the purposes of enforcing a judgment. But we do say it would be a little unfortunate if the wording of a freestanding disclosure order such as this, which is a standard form, it's not strictly a standard form, and it doesn't appear in the Commercial Court Guide, but it is the terms in which these orders are often made, as Melanie Trend said, were to be interpreted differently from the meaning of the disclosure provisions which are in the standard form freezing order, which still talk about the value of the assets, and on which Aspinall and Lim comments.
Yes. Now, Mr. Acker, it's not your fault at all. The court has had many questions for you, but actually you haven't yet, I think, even finished the summary of submissions we heard last time. And I'm quite anxious, given the time.
I have very nearly finished that.
No, that's fine. I say I'm not criticising you, but I just want to know how much longer you're going to need for your submissions.
Yes, I think my submissions, what I was going to come on to talk about is the, well, I have to deal with the ambiguous order point, and I don't think I'd actually dealt with that last time. I was about to, but hadn't.
Yes.
I don't think that will take
Fine.
a long time. Contempt 4, I don't think will take a long time, and then Contempt 5 will take a little more time. But I don't think I have more than, I would hope, 45 minutes to an hour in total from now on.
Well, what I'm hoping is, although I won't hold the parties to, is that we can finish by 1 o'clock the hearing. Given that this was supposed to finish in one day last time, And we were, I think, well through your submissions last time. As I say, I'm not criticising you or indeed Mr. Moxon Brown, but let's see if we can achieve that.
Pace, Lord.
Thank you.
I was just going to say briefly a point Lord Justice Snowden put to me last time, the wording whether they are solely or jointly owned in the order, and whether that indicates that value must mean gross value. And the answer to that was that wording is there to deal with points similar to the point Lord Justice Popplewell made, that there are cases of people saying, oh, well, I own this jointly with my husband or my wife, therefore it's not my asset, therefore I'm not disclosing it. And that it doesn't give any indication, or any helpful indication as to what the value of the assets means. It's just because someone might think they don't need to disclose a jointly held asset otherwise.
So you say that if we wanted to understand C in the way that you say we shouldn't read it, it means all other of the defendant's assets located in Morocco, of which its interest exceeds £75,000 in unencumbered value.
Yes. Even if solely or jointly.
Well, whether or not, but in other words, those would be the words that we say, that I think you say are obviously or necessarily by implication to be read into.
Yes. And that is the same in the case of a freezing order, because those same words appear in the standard form freezing order. And one can't see it in Mr. Justice Tier or Mr. Justice Mulder's freezing orders because we'd already got the disclosure order by that stage, so we took out the standard form.
And is this right? You also say we must read in a requirement to give details of all such assets and encumbrances.
What GHI can't do is what they did, which is to disclose the gross value of assets without also giving details of the charges. Now, that they might have said, we have a number of assets, they're all charged, our interest in them is nil, therefore we're not disclosing anything.
Well, but if the value is simply the gross value,
they would have had to disclose them anyway. Yes. And it's certainly misleading to disclose, we say, and we'll maybe go around in circles slightly, but it's misleading to disclose the gross value without giving some details of the charges, because, to echo the words of Mr. Justice Murray in Aspinall's, the claimant cannot properly assess the information disclosed regarding those assets without understanding the extent to which they're encumbered by a mortgage. Well, I think that is about where I got
So
to.
sorry, I'm guilty of holding you up. But you're not submitting, are you, that if value means gross value, that separately the requirement to give details requires details of encumbrances?
Lord, I am saying it would be a breach of the order to state gross value without giving details of the encumbrances. Yeah, that's the same thing.
Well, I understand that on the basis of your submission, that value means encumbered value.
Right.
But I don't think you're saying, but I just wanted to be sure, that if value means gross, there is still an obligation by virtue of the word details to give details of encumbrances. No, thank you. Thank you. I just wanted to be clear on that.
That brings us then on to the ambiguous order point, which has been dealt with more fully by Mr. Moxon Brown in his supplementary skeleton. We've dealt with it in ours as well, and your lordship's seen that.
Yes.
In short, we say there is no principle such as that suggested. It's not the law that because an order is ambiguous, there is no need for the court ever to determine what it actually means for the purposes of contempt proceedings. And indeed, the court is bound to find that there can simply never be a contempt if the order is ambiguous. The ambiguous order, that's the end of the inquiry. That is not the law. The cases don't support it, certainly not in any authoritative way. It seems to us, Lords, that if that principle did exist, it would mean that given an ambiguous order, a defendant could disobey it with impunity, even if, on its true meaning, it prevented certain conduct. And the defendant knew that, the defendant chose to do that conduct anyway. In other words, ambiguous order means no one has to, people can just disobey either of its two possible meanings without caring. It makes no sense as a principle because logically the first question is sensibly whether the order has actually been complied with. And for that purpose, the court has to construe the order. Of course, at that stage, it may be appropriate for there to be some strict interpretation, whatever that means in a particular case. And we do say, we do adopt Lord Justice Snowden's point that when one is looking at strict interpretation, that there are orders which can be construed strictly, and there are orders which are just ambiguous. They could mean A or B, and one can't say that B is more strict than A. So the strict interpretation test isn't necessarily the be-all and end-all of it. It is often used, indeed the cases deal with it in the case of injunctions.
I mean, this may have elements of both. I mean,
yes,
there are certain, to a certain extent, the value point is perhaps an A-B choice.
yes,
But it might be said, well, to the extent that you're asking the court to infer that in addition to giving details of the assets, you have to give details of encumbrances as well,
yes,
then a strict interpretation is, unless you say,
yes, I follow that one.
Give encumbrances, you don't.
Yes, I follow that.
So it could be both.
Yes. And the effect of a strict interpretation may be, of course, that what the defendant has actually done is not, on proper construction of the order, a breach of the order at all. But if, despite that, the order is held to mean, let's look at it in the context of prohibitory injunctions, if the order is held to mean do not do X, and the defendant does X anyway, then there is contempt if Masri is satisfied. There is no additional ingredient of the Masri's test which somehow they failed to mention in Masri in subsequent cases, that there's a threshold requirement of non-ambiguity. All the cases are doing in my submission is expressing the fairly obvious principle that if it was not clear originally whether the order prohibits X or Y, then it may not be appropriate to punish a defendant who believes he's entitled to do X, even if, on the true construction of the order, X was prohibited. In none of the cases is there any suggestion that the defendants in those cases knew of the true meaning of the ambiguous order. In Hadkinson, for example, there was very little evidence as to the circumstances of the breach. The actual point in Hadkinson, as we looked at this morning, was clearly obiter, since they decided they decided the case on the basis there was no breach at all on the proper construction of the order.
I mean, it may not be appropriate to allow a claimant which has put forward an ambiguous order,
Yes.
which, on its true construction, was breached,
Yes.
to pursue contempt proceedings at all.
Well, that would be a matter for the court.
I mean, there is a jurisdiction that Mr. Justice
would
brings,
strike out
just the safeguard type case management.
in an appropriate case.
If you can see at an early stage that because of the ambiguity, even though on its true construction it was breached, the court would not impose any material
Yes.
penalty,
There's no point.
there's no point. And that might reinforce to claimants the wisdom and the desirability of putting forward unambiguous orders.
Yes, and there are a number of cases, and there's been a little bit of conflation between the two, a number of cases which say orders should be ambiguous, which are directed towards the drafter at the drafting stage, or to the court at the making of the order stage. That
So orders should be unambiguous.
Yes, orders. One should take care to make sure when making an order that orders are unambiguous, and they say nothing then about, well, what happens if you end up with an ambiguous order anyway. So one needs to be a little careful about those cases. If one looks at the Abdiazov case, Abdiazov number 10, at paragraph 19, Hadkinson is cited as an authority on strict construction only. And indeed, the Wilson and Emmett case cites Redwing in the passage we looked at a little earlier for the same proposition, I say. And Redwing then goes on to quote Lord Justice Beatson in Ablyosov, where Ablyosov suggests that it's a question of strict construction only. So there is certainly a degree of fluidity, some judges looking at it in terms of ambiguity of orders and some looking at it in terms of strict construction, but it's not elevated to a principle of law, which says if you have an ambiguous order, all bets are off, that's the end of it as a matter of law. Can I move on then to deal with contempt 4? So this is new material. There was no dispute, there is no dispute, that GHI continued to trade. They were prohibited from disposing or dealing with or diminishing the value of any of their assets up to the value of 4 million. So 4 million is frozen. They can only continue to trade to the extent they have assets worth more than that. Of course, what they did, and we suggest they did deliberately, is decide that they would disclose to us real property in Morocco, inherently hard to enforce against, particularly given the attitude of the Moroccan court, which has now been overturned, of course. But they disclose to us property in Morocco. They make it appear to us that that property is worth more than 4 million pounds for the purpose of the freezing order now. I'm talking about not the disclosure order, when in fact it's encumbered. And on the basis of that, they consider themselves free to continue to trade with all their other assets, which they haven't disclosed to us, as they wish. That's what happened. The question the judge asked herself is whether she could be sure that they had dissipated assets in breach of the order. That's paragraph 90 of the judgment. So any argument that she did not address the correct burden of proof, as it appears in my learned friend's skeleton, is simply wrong. She concluded that she was so satisfied. And that is in part because the way that the appellants put their case to her was not to advance any positive case, or any real positive case, but merely to suggest to her, in what she called an ambitious submission, that she could not be so sure because there might be assets, each of which is worth less than $75,000, so it doesn't have to be disclosed, but which cumulatively add up to more than $4 million. So we have lots of, if I can call them this, small assets. We might have those, they said. Not we do have those, but we might have those. So we weren't supposed to disclose them. Who knows? You can't therefore be sure that we have dissipated. Mr. Hilton, for it was he, I expect was in a difficult position, because he couldn't positively at that stage say, actually, my client does have lots of assets, because that would bring to light the inadequate nature of their disclosure. So he put it in the terms that he could, that, well, we might have such assets. Their case now appears to be that their own assertions as to the extent of their assets were so unbelievable that the judge should have assumed they were incorrect. And that is indeed an ambitious submission for a number of reasons. First of all, the whole point, as I said, of the financial limit in the disclosure order is to exclude from consideration a number of relatively small value of assets, because it is inherently unlikely there will be a sufficient number of small assets to be worth greater than $4 million in aggregate. It's possible, but it's not likely. Second, there were some bold assertions put forward by GHI as to why they said they were entitled to trade. What they said was that their asset disclosure demonstrated that they had real property well in excess of 4 million. And one can see reference to that in the transcript before Mrs. Justice Cockerill in supplementary bundle tab 2242. The email is in French, but there is at least...
Just give me the reference. So supplementary bundle.
Tab 20, page 242. And indeed, the actual French email, if one cares to look at it, is at supplementary bundle 137. It is, as I say, in French, and both Mr. Hilton and I had a go translated it in the transcript, which is not entirely satisfactory, but there we are. Of course, no such assets worth in excess of 4 million were ever disclosed. The bank accounts they disclosed had nothing or very little in them. All the properties which were said to justify the trading were charged. And this question about encumbered or unencumbered assets in the context of the freezing order doesn't arise because it's said to be clear there. And third, as I said, there was no positive case put forward by GHI that it actually had assets below those valued, just we might have assets. So the judge was perfectly entitled, and indeed we say correct, to conclude when she gets to paragraph 91, that GHI had chosen to rest its case on broad assertions of assets well in excess of 4 million, without providing the slightest detail of anything except the incorrect material in its asset disclosure. And she was certainly entitled to infer, in all the circumstances, on the evidence before her, that if GHI did have such assets, it would have said something about them during the previous several years that we've been trying to enforce. They could at any stage have said, we have all these other assets, here are 300 pages of balance sheets, but they didn't. And although, of course, the legal burden remained on us at all times, the evidential burden had clearly shifted to them. And there can therefore be no suggestion, contrary to Learned Friend's grounds of appeal, that a very experienced commercial court judge somehow forgot what the burden of proof in a contempt application was. And that is exactly what happened. Not the judge forgot, but the same analysis is in the Viz trading case, which is in the First Authorities bundle at tab 10. And can I read your lordship just a couple of sentences? Tab 10, page 242. And it is sidelined, it's paragraph 31, but I'll just read the last bit of paragraph 31. It says, if the contemnor chooses to remain silent in the face of that dispute, the court can draw an adverse inference against him. If the court considers that to be appropriate and fair, and recalling that silence alone cannot prove guilt, this is not to put the burden of proof on the first defendant, far from it. The burden remains on the claimant. So that was a freezing order case in which the defendant says nothing, and the court was entitled to refer to it, saying that the burden of proof on the claimant had been discharged. So this isn't a reversal of the burden of proof case, it's a judge sensibly saying, you've known for all this time that an application is being made against you that you have failed to comply with the terms of the freezing order. It was always open to you to disclose assets. You haven't done so. You haven't advanced a positive or a strong positive case. You've just made some bold assertions, and therefore I'm sure on the evidence that you have continued to trade in breach. And that is, I respectfully suggest, unimpeachable. My own friend now seeks to rely on our evidence, namely the evidence from Miss Pritchard in January 2019, and indeed her evidence is as to the position in 2017, which were the documents then available to her. So that again is not really a point they made at the time, but it won't avail them in any case. It is clear, one only has to read Miss Pritchard's affidavit, which is in the second authorities bundle. No, it's in the supplementary bundle, seventh affidavit. That what she says is, here is some material we have found out about the defendant's assets. It doesn't make much sense. This bit is inconsistent with that bit. We have found some bald assertions as to share capital and equity. I don't know the up-to-date position because I can't get hold of anything else. Please can we have a disclosure order? And the court says yes. She exhibits some accounts from 2017. That is all that was available. She notes some cash assets of 15.2 million, but she says that seems wrong because we'd written to all the banks who'd said, well, we don't have anything. So that looked a little fishy. And she says I'm lacking up-to-date information. And of course, following all of that, we've got the evidence from Mr. Boutguery himself saying there are no assets, in essence, and establishing that the banks have no money. Undoubtedly, the judge was entitled to rely upon what the defendants themselves said, the appellants said about their own assets. There is no indication she ignored what Miss Pritchard said. One can assume she took it into account. And respectfully, therefore, we rely upon the point that Lord Justice Snowden put to my learned friend on the transcript from last time. Why does the judge have to extrapolate from historic figures to an assumption which is different from the actual evidence that your client produced? Because on the one hand, she has historic figures from audited accounts. On the other hand, she has your client's up-to-date, what your client has said with terms of the disclosure order. Why is the judge obliged to disregard what is actually put in front of her by your client in favour of some assumption as to what might be the current and up-to-date position of the company? Well, what would we say exactly? Lastly, on this point, my own friend seems to be taking a point about publicly available information. As I understand it, the suggestion is that we must have known about all the assets which have been subsequently disclosed. Therefore, if those assets had been dissipated, one can assume that we would have told the court about them. We would have said, we know about all these assets, they're being dissipated. We'd have advanced contempt on that basis. And that since we didn't, the judge was entitled to infer that they had not been dissipated. There are, can I suggest, a number of problems with that. I will restrict myself to three of them. The first is that submission was never made to the judge. The second is that Mr. Moxon Brown himself said at the time that these documents are not from published accounts. And one can see that in the supplementary bundle at page 263. Which is tab 21263 is the transcript from Mr. Justice Cockerill's hearing, where he says that letters E to F. What we have got here are pages and pages. I think there are 390 pages of balance sheets, these are not from published accounts, but they are certified by the auditors and show the balances for 2019, 2020, and 21, written in French, very detailed, etc. It's not apparent to us exactly what he was talking about and what is published and what isn't published. But certainly it seems that a quantity of material is not from published accounts. Perhaps the auditor's reports are. Ms. Pritchard said it was all very confusing. And the third problem is, I can tell you as a matter of fact, that in fact we didn't know anything about those assets. I mean, this is a new point to which we're entitled to respond. We didn't know anything about that, which is why we made the application that we did. And there's simply no inference from that to be made, even if one could follow the convoluted logical steps for getting there. Contempt 4 is clearly established, and the judge was right to hold as she did on the evidence that was available to her. And as the Lordship pointed out, there is in reality no further evidence available to Lordships in any event, although we know what it is said to contain. Contempt 5, then, the preliminary point, which I've already alluded to, is that this is the paradigm example of a new case, and I won't deal with that.
Yes, well, we have that point. We understand that's your submission, and we also have your very helpful written recent submissions of the 8th of December.
Yes.
Just having an eye on the clock, would you be able to complete your submissions in the next 15 minutes?
Yes.
Thank you very much.
I will, and I will have to. The power to commit is of ancient origin. It's part of the court's inherent power to ensure justice is done and to ensure compliance with its orders. We've set out, as your Lordship said, in the supplementary skeleton, the famous passage from Lord Oliver in Attorney General and Times. I won't repeat that. It's clear that it is thought to be essential to the protection of rights which underpin civil society. The power to commit is very important. And I do suggest that the power to imprison directors or officers is merely part of this. It's an aspect of this. It is the court exercising power to imprison a direct officer, which derives from the ancient powers to imprison members of a corporation to ensure compliance with their orders. And this is no more a procedural matter than the original power to imprison itself is a procedural matter. Indeed, that is why it is sensibly referred to as a power to commit. Of course, there are procedural aspects to it. It is overlaid and governed to some extent by procedural rules, such as when claims may be brought, in what form, penal notices, service, all of those things which are initially thought of as procedural. And it is the latter which the rules now deal with, and rightly deal with. If one starts with what the rules themselves say, and I won't take lordship to the rules because I'm assuming lordships recall the general setup,
Yes.
but I will if asked. The old pre-2020 CPI is in Authorities Bundle 2, page 68. Proliferation of versions, but that's the pre-2020 version. 81.1 says, here is a statement of the purpose of the rules. They are procedural only. Paraphrase it. 81.2 affirms that the rules are procedural, but it expands on that, and it confirms that the rules do not concern themselves with the court's power to make an order for committal. It says that expressly. And it must follow, I suggest, that any power to commit, which the rules say is not dealt with here, must come from somewhere else. The power is not provided by the rules and wasn't thought to be provided by the rules before 2020, in 2020, before the reforms. Notwithstanding that apparently clear statement, in two places, the rules don't create any power. My learned friend suggests that is exactly what they've done, and that they've done that by way of 81.4, the old 81.4, which is the provision which is now gone. And I suggest that the rules have not forgotten what they said two paragraphs earlier. 81.4 is not there to create a power. That is not the source of the power. It is there for other purposes. And that purpose is merely to recite the existing power, common law power, the inherent power. And the alternative, that the rules say they're not creating any power and then just do exactly that, makes no sense. And that is entirely normal. And we can see that from the notes in the White Book, which I've referred to in my skeleton, on page 69 of the Second Authorities Bundle. Page 70 of the Second Authorities Bundle at tab 6, in the notes, which says at the top of page 71, relevant law is found in case law and statute, which together form an extensive and complicated body of law and not in rules of court, which are confined to matters of practice and procedure. Frequently, for purposes of exposition, it is convenient, if not necessary, for rules of court to declare, recite, or acknowledge expressly or impliedly the legal basis for the substantive law. So that's exactly what's happened here. They are reciting the common law position. Your Lordships, I think, discussed with my learned friend a couple of reasons, particular reasons why that might be appropriate, which we adopt. I think Lord Justice Snowden said perhaps it was thought that directors might need a reminder as to what the common law position was. Lord Justice Popplewell said that without that reminder, one might interpret the rules as not making it sufficiently clear. But whatever the actual purpose was, it is a recitation of law. And the rules themselves make that clear by saying they're not creating a power. And there is support for that view, importantly, from the members of the Civil Procedure Rules Committee themselves, which I'm sure I don't need to remind your Lordship consists of the Master of the Rolls, the Head of Civil Justice, several distinguished court judges and others. not suggesting the others are not distinguished. Can we turn up Lord Justice Coulson's forward to the consultation paper, which is on page 390 of Authorities Bundle, say Authorities Bundle 1. Yes, it is. Authorities Bundle 1, page 390. And it's the third paragraph onwards on 390. So this is the consultation document which went out before the rule and is referred to by Justice Foxton amongst others. We have, in July 2019, the CPRC set up a subcommittee to consider the issue. At its September meeting, they endorsed the view of the subcommittee that the procedural aspects of contempt proceedings are causing frequent difficulties, and the subcommittee should look at ways of simplifying, shortening, and strengthening the procedural rules. Then in the next paragraph, Part 81 comprises rules moved from the RSC with little amendment. Subcommittee undertaking this exercise in 2010 was not given the remit to simplify and rationalise the procedural rules. It was a lift and shift exercise. And consequently, Part 81 is segmented, long, complicated, and repetitive. It replicates substantive law, as well as dealing with procedure. The procedural content is then largely repeated in a practice direction. So that's their idea of what the procedural content was, and that's what deals with penal notices, etc. But replicates substantive law was a problem. And then the next paragraph says, the existing Part 81 is not easy to operate in present litigation environment. In a redrafted Part 81, we propose a new approach, which A, omits nearly all the substantive law. So that's why it's gone. It was a recitation of substantive law, which was leading to confusion, amongst other things. It was unnecessary. We want the new rules just to deal with procedure. Let's remove the reference, the express reference to directors here. And we will then deal with procedure in rules, not PDs, create a uniform procedural code, etc. So they're looking to strengthen the law, not weaken it, by removing an important power. They acknowledge that 81 replicates the law, and that is why it is being removed. So putting it shortly, the fact that the reference to the power has gone does not mean it no longer exists. It was removed on purpose because it is substantive law, and that's what one gets from the rules themselves, and indeed from this report. And the alternative view espoused.
Sorry, just I think you said a moment or two ago that they were looking to strengthen the law.
They're looking to strengthen the rules.
Correct. I mean, it
would be odd if they do that by removing the court's power to commit directors to prison.
Well, I mean,
or leaving it to the criminal contempt jurisdiction.
As I understand it, you say that the substantive law has not changed. It's always been there.
Yes.
What they've done is simplify the rules, shorten them,
taking out substantive law,
and to that extent strengthen the rules. But it's no part of your submission that they were attempting to strengthen the law.
No. But it is part of my submission.
Maybe I just misheard you.
No, certainly they weren't seeking to weaken the substantive law by removing a useful power.
That is, yeah.
And what my learned friend appears to be submitting is either call it the body corporate provision, which is what Mr. Justice Foxton calls it, was simply omitted by mistake, or it was effectively revealed on purpose, repealed on purpose, with no fanfare, no mention at all of the fact that it was going, nothing in the pre-report saying that this was going to happen, no indications of any particular problem with it, in circumstances where the stated purpose was to strengthen the position. So both of those is an extremely unlikely scenario. The coherent way of reading it, as I've said,
or not to weaken. Sorry,
not to weaken.
I'll just make the same point again.
Yes, exactly.
It's not to weaken.
Yes,
but they weren't actually seeking to strengthen the law.
No, the law is the law.
So it's
and
your actual submission is they weren't seeking. It would be odd if they were intending to weaken the substantive law by strengthening the rules, which is what they say.
Yes, yes. Certainly no intention to repeal it, as opposed to merely removing it from what is a procedural set of rules. And if one reads the rules normally, and indeed in accordance with the overriding objective, which is to deal with cases justly, and that includes enforcing compliance with the court rules, that is the conclusion one reaches. So the rules themselves make it clear that the power is untouched. That there are just a couple of subsidiary points in conclusion, if I may, with some trepidation given what Justice Popplewell has uncovered. The first is as to the source of the power to commit a direct. I've suggested it's part of the court's inherent jurisdiction. It is, or at least was difficult for us, to trace the precise origins of that. That is sure. We did some digging. The cases we came up with, clearly not the best, were the Guildford case, which is in the bundle, including a transcript of it, and London and Lynn. And they are both examples of a writ of attachment being issued not against a corporation, because the writ of attachment does not lie against a corporation, but against the members of a corporation. So mandamus, of course, the forerunner to the injunction, or at least the version of the injunction which was in the court, the King's Court, as opposed to the Chancery Court. Mandamus is issued, the corporation does not comply, and the mode of enforcement, as Lord Justice Popplewell said, is attachment, which nowadays is thought of as attachment of assets, but back then was attachment of the body, or at least could be attachment of the body, namely arrest, people would come before court and then would be dealt with appropriately. So there was power to attach members of the corporation where the corporation itself could not be proceeded against. We then come to the Common Law Procedure Act 1860, and that I think is worth a quick look at in Authorities Bundle 2, at tab 3. This is the extract from James Stevens' book.
Yes.
And one can see it on page 6. This is where I got my first hints about the Guildford case, because it's referred to in his book. More of the old case on mandamus.
Sorry, I've lost this.
So it's page 6, which is tab 1 of the second authorities bundle. I think Mr. Justice Foxton said he'd looked at a number of these cases and found them a little impenetrable. Perhaps their meaning was lost to the modern eye, I think was his phrasing. But doing the best we can. Section 32, in all cases in which a writ of mandamus or of injunction is issued under the provisions of the Common Law Procedure Act 1854, I'm sorry, I'm looking at the wrong section, which doesn't help.
You want 33?
It's the next one, yes.
Yep.
33 down at the bottom of the page. Writs of injunction against a corporation may be enforced either by attachment against the directors or other officers thereof, as in the case of a mandamus, or by writ of sequestration against their property to be issued in such form and tested. So what we have in my submission is that for writs of sequestration, it says you can proceed by writ of sequestration, and this is a procedure for it. And that's also what is being said in the first part, that it is confirming that writs of injunction against a corporation may be enforced, and that the procedure for doing so is the same as, or substantially the same as, what one does in the case of mandamus.
So your point is really this, that, well, sorry, let me just finish, if you don't mind. Your point is that Parliament wasn't creating the substantive law on this because it draws an analogy with mandamus. That's why it uses the clause, as in the case of a mandamus. So in order to understand where was to be found the power of attachment against the directors or officers of a corporation, you had to look at the pre-1860 case law about mandamus.
Yes.
And what it's now doing is that it's saying that that power can also be used to support a writ of injunction.
Well, all it is saying is that if one is looking for the procedure for doing so, it is the same as the procedure for mandamus.
Right. Okay.
And just because in same sense as it is recited in the later rules up in 2000, it's being recited here as a power. It is not the creation of the power. This is the Civil Procedure Act. It is setting out the procedure for proceeding in this way.
Yes.
It's doing a little bit more than that, because in the case of mandamus, you couldn't previously enforce by attachment an order against a corporation. And that's the point that Mr. Day makes in his book.
Yes. And he seemed to think there wasn't any pre-existing mandamus jurisdiction. With respect, I think he's wrong about that. And Stephen seems to disagree with him.
I'm not sure that's what he was saying. I think he was saying the words "as in the case of mandamus" seem to assume that if you had an injunction against a corporation, with a mandamus against the corporation, you could attach the directors under that mandamus. That was never the case.
Yes. Yes.
So this is actually making a development in the law.
Yes.
By short-circuiting.
Yes.
What might need to be two mandamus.
Yes.
If that's the correct law. So you don't have to get your extra mandamus against the directors before you can attach them.
Yes. Yeah,
that's the point he was making.
And that can be seen as a procedural step, not a substantive creation of a power step.
Because substantively, you could achieve that result, although it previously required two steps.
Yes. Which is why it is in the Civil Procedure Act and not in something which isn't a Procedure Act. But there we are. I think various people over time have sought to find some predecessor or explanation for this part of the statute, and no one has got any further than Stephen today.
No, Mr. Acker, we have, I'm afraid we've exceeded the time that we hoped you would need to complete your submissions, but how are you doing?
Can I take 30 seconds?
Yes, of course.
Stop. The last point on part 81 is it is said that we don't need this power anyway because we have the criminal contempt jurisdiction. Obviously that is different, and one way in which it is different, which I think no one has mentioned, is regarding extraterritoriality, and that's dealt with in Dar el Arkan, and it is certainly debatable at least, and I'm not conceding the point, that one cannot proceed against a director who is out of the jurisdiction under the criminal contempt jurisdiction, because either there will be no contempt or he will not be subject to the criminal jurisdiction of the court. That may be different in this particular case because of submissions to the jurisdiction, and I'll take it no further than that, but your lordships ought to be aware that there is potentially a problem if your lordships were to hold that we can just leave this to the criminal jurisdiction in the very common case of companies with directors abroad.
Yes.
And I wasn't going to say anything really about sentencing at all, apart from the general principle that your lordships in this court should not interfere with the first instance judge's conclusions on sentencing, and there are authorities for that, and they are in bundle. So I'm sorry, I overstayed my welcome.
That's very helpful. May I check if my lords have any further questions for you? No, that's very helpful indeed, yes. Now, Mr. Boxon Brown, how long do you think you'll need to reply?
Well, my lord, I'm looking at the clock. I try and finish by 1 o'clock.
Well, if you need to go slightly beyond 1 o'clock,
well, I was going to say,
don't feel under any undue pressure. But let's see how we get on.
yes, thank you, my lord. So I want to deal with ambiguity first. In our submission, the nub of the question that you need to address is what really is the purpose of a disclosure order as opposed to a freezing order Is it simply to point the finger at the whereabouts of potentially substantial assets, leaving it to the judgment creditor to find out whether or not it's worth proceeding against that particular asset, or is it to go further and to reveal the equity in those assets if that equity exceeds $75,000 at the date when the disclosure is given? We respectfully adopt the point made by my Lord Justice Popplewell, which I think I may have made perhaps less elegantly on the last occasion, that of course if the proper construction of this order relates only to equity and to the disclosure of encumbrances, there was of course no need for this defendant to make any disclosure at all, at least on the claimant's case, is that none of these properties had any equity above $75,000. And so one asks, in terms of the purpose of the order, is it more useful to have the finger pointed at assets which may be, on the day when the inquiry is made, some utility so far as satisfying a judgment is concerned, or to have complete silence? And in our submission, it's obvious that it's better to be told where the assets are, leaving it to the judgment creditor to do what he chooses about it. But the alternative is simply not to have the information. We also respectfully adopt 2 points made by my Lord Justice Snowden in comparing the material part of Mr. Justice Waxman's order relating to properties with the first and second parts of the same order. First of all, in relation to bank accounts, where there's no mention of equity, and as has been pointed out, it is usual for a company's positive bank accounts to be the subject of some sort of charge, but no inquiry is made about that. It is understood that it is as it were, the gross position which is being asked about. Why should it be different? A few lines further on, when one comes to the third of the orders made, and perhaps even more remarkable, the second of the orders made by Mr. Justice Waxman, which doesn't even specify whose assets it is that are to be disclosed. They could be, they could belong to a chargee, a chargeor, or to some shared ownership. It is simply at large. And we say, looked at if you look at the whole order, which is a useful thing to do when you're trying to construe a material part of it, that suggests that what is the third part of the order relates to the value of the property and not to the value of the equity. If I can turn from there to the CPR
Yes.
point,
Yes.
the nub of that point in our submission is to try to locate the source of the power to commit directors, to visit upon directors the sins of the sins of companies. That's what it comes to. Where does that power come from? Anywhere outside of procedural rules or not? Lord, I respectfully adopt now the formulation or the conclusion reached by Mr. Justice Foxton on this issue, having previously, I think on the previous occasion, somewhat denigrated it as being mere semantic. What he found was that the power under the former Rule 81 was substantive in content, but taking effect via procedural statutes and rules. Now, he had made an inquiry, rather of the kind that my Lord Justice Popplewell was making in looking at some of the old cases, and he concluded, whether differently from my Lord Justice Popplewell or maybe the same, that those old cases were difficult. And the conclusion he came to was that he could not locate, it seems, a pre-existing power, but that the power takes effect, is the important words, via procedural statutes and rules. And we say, if you take away those procedural statutes and rules, what are you left with? If I can just engage for a moment with my Lord Justice Popplewell's thoughts on this topic that he was sharing with my learned friend Mr. Hilton this morning, I would invite a test for the approach that my Lord suggested by asking, where would we be in relation to the power to commit directors were it not for the series of procedural rules which have been enacted? There are difficulties about those old cases. Mr. Justice Foxton, who gave careful judicial thought to this, found them perplexing or found them challenging as to what they actually meant. To launch an argument on cases that were decided before the development of separate personality for companies in the course of the 19th century, culminating in the decision at the end of the century in Salomon and Solomon, to say that there is a pre-existing power which does not need any genesis in rules or statutes is, in our submission, a very bold step. Imagine there were no rules or statutes at all dealing with this. As far as I know, none of the old cases deal with the question of contempt. What would happen if it came before a court, absent the power to commit directors for contempt found in rules, and reliance by the claimant on those old cases with nothing more? In our submission, a court would reject the idea that there was a sufficient juridical basis for imprisoning directors if all that could be shown was a number of old cases which are difficult to construe, partly because of the way they're reported, and which don't in any event relate to contempt. And I would remind you respectfully that it's not just a question of a director's liability for the contempts of companies. It's the whole idea of visiting directors with the wrongdoing of the companies that they control. And I pointed out in my written submissions initially that although there are numerous statutes making directors liable for the contempts of their companies, in the area of food and drugs and all kinds of different areas where companies are enjoined from doing things, and it is said that the director, by statute, is also liable in certain circumstances. Well, of course, there'd be no need for any of that if there were some inherent power derived from the old cases to pre-Salomon and Solomon to say that directors had this liability. And so, with profound respect to my Lord Justice Popplewell, I would say test that proposition by saying, could you really sustain it in a court if you hadn't got the statutes to fall back on? Lords, the final matter I wanted to deal with, just very briefly, was punishment, sentencing.
Yes.
You'll recall that on the last occasion, although it's a very important part of the matters that the the appellants want to put before this court a sentence of immediate imprisonment of 1 year for count 3 and 6 months concurrent for count 4 and a fine of 75,000 on GHI. I had run out of time. It was after the short adjournment on the last occasion, and I was constrained to say simply, you'll have to look at my written submissions on that, and I didn't say anything. I knew, because it's been his attitude throughout, that Mr. Acker was unlikely to say anything about sentencing because he considers, I think, in our submission rightly, it's a matter for the court. And so I didn't think I had the right, probably in a reply, which is why I suggested earlier that I might want to just touch on it. It's a single point I want to make. It is, of course, conceivable that you reach the conclusion that the order of Mr. Justice Waxman was indeed ambiguous, but that you're not persuaded by my Redwing argument that that means that therefore the contempt falls away. So what you're left with is a contempt, but a contempt based upon a misreading of an ambiguous order. There is, I think, in what is on any view unsatisfactory affidavit evidence, there's no real evidence as to how it came about that in the first instance, Mr. Boutguery didn't give any details of encumbrances on the company's properties. The company was asked to do so in correspondence with the claimant solicitors, and within a fairly short time, some details were given. Now, quite what was going on is not in evidence, but in this situation, you are, in our submission, respectfully not entitled to assume that there was any bad faith or intention to evade. It was simply an interpretation of the order, which on the findings I'm predicating is wrong. If you do come to that conclusion, it would, in my submission, be wrong in principle to visit the assumed contempt with a sentence of imprisonment. And I think Mr. Acker himself was in arguing that the Redwing principle for which I contend is wrong, recounted a fallback position that the right way to deal with a contempt, which is an order which is ambiguous, but nevertheless amounts to a contempt, is in sentencing. Yes. And I would ask you to do exactly that.
Thank you very much. May I just check if my lords have any questions? We're very grateful to all concerned, not only to the advocates from whom we have heard, but to their whole teams. We're well aware of how much work has gone into the preparation and presentation of this appeal. We will take time to consider our judgments, and they will be circulated on a confidential basis in the usual way. May I just emphasize, because not everyone is always aware of the court's procedures, that when the confidential draft is circulated, it is only for very limited purposes, and the court takes very seriously any breach of the embargo at that stage, and that itself may constitute a contempt of court. Unless there's anything else, thank you very much.